Constitutional reform is a critical aspect of building and maintaining a democracy. It's essential to ensure that the constitutional framework is relevant, responsive, and reflective of the needs and aspirations of the society. Today, we look at that and more with Bishop Dr. Alvin Bailey, Chairman of Jamaica Cause and Senior Pastor of the Portmore Holiness Christian Church. Welcome to the conversation. How are you?
Thank you very much. I am very well, thank you.
All right. So there has been a lot going on as it relates to conversations around constitutional reform, and you're here for us to look a little deeper into that, and we want to find out, do you think that constitutional reform is necessary, or do we simply just need amendments?
No, man, absolutely necessary, especially in the life of Jamaica at this time, when we're looking forward to our divorce with the monarchy and an embracing of a republic that certainly reflect the mind, politics, purpose, and pursuit of a people. It is extremely important for us, and I think the exercise of reform is very pertinent, very timely, and one that I think has gotten the support of Jamaicans here and abroad.
Here and abroad. So, so do you think that the public is fully apprised of the role that they are supposed to play as far as constitutional reform is required?
Unfortunately not. I don't even think that the public is properly informed as to the importance and necessity of the Constitution of Jamaica.
Why would you say that though?
Well, pretty much even now, as the responses are many, and we are hearing many different responses to the way the government has approached it, we realize that people are not, and especially with the inclusion of foreign national and so on, I think it is disengaging a sense of national pride and dignity. But then, albeit, I think that even the absence of a deliberate effort to inform us as to the necessity to change it and the importance of it reflecting our intent is evidence that we don't even take it seriously enough to assume the role and responsibility to inform our people.
All right, but you stated something about the inclusion of foreign nationals in it, but Jamaica would not be the first, second, or third countries. There are countries that I can pull off the top of my head, Sri Lanka, Tunisia, Egypt, for example, and quite a few others that have included the expertise of quote-unquote foreign nationals. So why would that be any different, or why should it be any different for us?
Well, I can see you are throwing us in at the deep end. Well, the societies of the world are now being impacted by different kinds of lifestyle of individuals who are imposing on the life of a nation in many ways. It becomes important that as a nation we ensure that the authenticity of our culture and purpose as a people be reflected in, supported by anyone who has to do with our sacrosanct instrument that will guide us as a nation and as a people.
So you mentioned the idea of this instrument being sacrosanct and the fact that we have to be deliberate in terms of who we include in it. But what disadvantages do we stand to face if we should include someone? Because it's a committee.
Yes.
So we can appreciate that it's going to be more than one. And being a man of the cloth, so to speak, there is wisdom in the abundance of counsel.
Of course.
So what difficulty or what disadvantage would the inclusion of any individual bring?
Very good question. And I think that any individual who has to do with the document can be included at different levels. You can be, as it is now, on the committee, or you can be a consultant.
What would be the difference, though?
The difference would be, in my estimation, it is going to be named persons who are the framers, rewriters of the Constitution. Their names will go down in history. And I think it must reflect 100% Jamaican national. However, the person who give information, counsel to the document must, as it is, they give counsel, instruction, and should really not be a part of the authenticity of the instrument. So I think the difference is in the interest of national pride, generic interests, authentication. It must be 100% Jamaican. There must be no perception there must be no second thought as to whether or not it reflects us as a people. And so to be a part of the committee is separate and apart from being a part of a consultative body that gives information. And there's a significant difference.
But you would agree, though, that there's going to be a difference, yes, in terms of who. Because, for example, if, let's say that I was a consultant,
yes,
then my influence would have been different as opposed to the president of another country being a consultant, or someone who is a scholar from another jurisdiction being a part of that committee or being a consultant, just as I am. You understand that the differences of our scholarly background would obviously impact our contribution, irrespective of whether or not we are on the committee or we are going to serve in the capacity as a consultant.
I kind of fail to see why we refuse, in embracing a sense of national pride, to have a constitution that is 100% Jamaican, writers and framers, and wanting to insist, the insistence of having a foreign national, especially one that represents a nation that have a different kind of ideology than ours, has a personal interest that is different from ours. Why would we want to be so insistent? If he is able to serve in a consultative position, why are we so insistent on him serving as a member of the committee? Oh. Is there a hidden agenda?
All right, so you stated that there's an individual now. So I'm going to ask you, what's the difficulty? Who is this individual, and what's the difficulty that you have with this individual being included in the crafting of the constitutional reforms?
Well, the person who now has surfaced as the person who we have included in writing on the Constitution Committee is one who is a prime proponent of the LGBT lifestyle, derivatives, function, and everything that has to do with that group of persons, and also supports abortion. Now, it happened to be that in our nation at this time, both things are illegal. Mm-hmm. No, I think we have just questioned the seriousness of our laws, the integrity of our everything. If you are going to have one who is a main proponent, undermining our laws, it's an undermining of our laws, undermining of the culture and preference of our people, because we would have done polls that says that Jamaicans are saying no to these things. Yet you have one whose name is going to be mentioned, who has not hidden his position on these matters.
He has not hidden his position. But
remember, he's not a Jamaican, you know. He is a foreign national.
So it would have been better if he was a Jamaican?
He's a foreign national who can serve in a consultative position rather than being given the distinguished privilege of being a part of our committee, especially when the things he supports are illegal in Jamaica.
So the question is, would it have been different or better if he was a Jamaican national with the same views that he has now? I
first want to underscore, and I'm going to respond to your question. I don't run from questions. So I first want to make the distinct difference between imposition of that which is not a part of our culture and practice and behavior, the significance of a kind of imposition, a kind of entertaining and having a part of us, of somebody who is saying something different from we are. I think a sense of moral rectitude and integrity is brought to bear when you know that you are not 100% for what somebody else embraces, but you choose to be a part of it. But let me answer your question. If it was better that he was a Jamaican,
yes,
we are aware as Jamaicans that we have our issues to deal with, issues that are intrinsically Jamaican. And so we will deal with our own national, our own Jamaicans who have issues in one area or another. But I will hurry on to say that in the interests of the integrity of the instrument that we're now talking about, if somebody who sits on the committee knows that he cannot recuse himself or absolve himself or cannot be objective as it relates to the exercise, he is to have the moral rectitude to exclude himself. And if...
But you're making an assumption now that he's not able to be objective.
No. I'm saying if he knows, but I don't think. I think your objectivity is questioned by virtue of your philosophy. In other words, I'm a Christian.
Yeah.
And my Christian philosophy guides my every life.
But there are Christians that believe as he does.
If I have no reason to think that his that his belief in these matters are not as strong as my Christian belief.
No, but I'm saying that there are Christians who believe similarly to the way he does in some of the things that he believes as well.
Well, can I tell you? And again, I could say there are Christians and there are Christians, there are Christians. But if I'm going to subscribe to the Judeo-Christian philosophy or doctrine or life worldview, then the Bible specifically, unequivocally speaks clearly against the practice of abortion and homosexuality. So people can say they are anything, but if you're going to take a biblical position on the matter, we are constrained by the teachings of the scripture as it relates to homosexuality and abortion.
All right, so I'm happy that you stated that so clearly. I don't think that you have answered the question fully, though, because I'm looking at the fact that we have a gender specialist on the committee, namely Dr. Nadine Spence, who shares similar views and sentiments to what he would share as well. Do you have an issue with her being on the committee?
And I'm saying to you, if there are just some calls that we cannot make. Let me give you an example. We are, in our Christian setting, believe in what is called tithing as a fundamental part of the Christian practice. I do not know who are the people in my church that pay tithe. I don't take an interest in it. But I do say to the people who are with me in leadership, if you know that you have reservation as it relates to tithing, have the moral rectitude to excuse yourself from my committee, because I am not. It is not comfortable for me to be pastoring with one who has a diverse or a difference in teaching on the matter. But you know what I'm saying? I draw the line because, as it says, persons have choices. But I think choices and morality and ethic goes hand in hand. So I will not say, for example, that these persons, because they have aired their views, have to be excluded from the committee, especially when they are Jamaicans, and that qualify them.
So that's what I'm trying to get at. So it seems now that your only issue with him now, the primary issue rather, with him is that he's not Jamaican.
No, because I'm hurrying on to say that if one of these persons, Nadine Spence or anyone else for that matter, feels so strongly about the Constitution or about their practice that he or she intends to skew the Constitution to support the matter. Look, we don't know enough.
No,
don't know.
Let me just hold you right there because we're going to our first break. Ladies and gentlemen, this is The Conversation. Welcome back to The Conversation. Today we examine the Constitutional Reform Committee, a 14-member committee that was earmarked by the Prime Minister, and we have certain interest groups, primarily the church, and former or similar coalition groups that are contesting the inclusion of one Professor Richard Albert on this committee. And we have, for this discussion, Bishop Dr. Alvin Bailey. Welcome back.
Thank you.
So we looked at the issue of his inclusion. You stated that it wasn't just because he's not Jamaican, and you cited instances in the church, for example, if someone had an issue with tithing, that you would ask them to excuse themselves from the committee. And just before we went to the break, we started looking at the fact that we have other individuals on the committee that share similar views and sentiments.
Sure.
And I was trying to find out whether or not you would say then that these persons should also excuse themselves from it. That's what you're saying? Yeah,
that's what I'm saying. No. I'm saying, and this is a very sensitive issue, Jamaica is not a theocracy. And I don't have to be told that. It's not a theocracy. But we are significantly informed by the Judeo-Christian worldview. I mean, we're surprised in Parliament. Our national anthem is a prayer and is the God of the Christians that we're talking about.
But that's similar to many countries in the world where we're secular, but we still have religious leanings.
It is not a theocracy.
Exactly.
But we have a significant leaning leaning towards the Christian way of life, because the way of Christians, the saying of prayers, the calling of the name of Jesus and God is a significant part of what Christianity. But I am aware it's not a theocracy, and it's a secular a society, and so secularism plays an important part in it. Our secularism, however, excludes certain practices as is known. But however, we do not police some of these practices as per se, but some persons are practicing a number of things.
The question is, how could you police them?
No. I want to answer your question.
Okay.
And so the individuals who, in fact, practice lifestyle that are illegal in Jamaica, they are, unless they are caught in the act, or in fact somebody report on them, they are not brought to bear. And so, like everything else, if the person inclusion on the committee is not because of this lifestyle, then there can be no objection. I would certainly be at the forefront objecting if the Prime Minister or anybody puts somebody on the committee because they are LGBT or because they have done and support an abortion. I would have a problem with that.
So obviously then he's not included, and Dr. Spence, for example, and many others are not included because they they lean towards that.
No, they are not.
Okay.
First of all, that's not my understanding. However, bear in mind that there's belief out a road. You know what outer road mean? People have it
in the streets.
Right. That that government have a hidden agenda and are, screechy, are putting persons, finding a subtle way to put persons on it. I'm just telling you what is on the street. I do not subscribe to it. Let me just make that very, very clear. You know why?
Why not?
Because I have recently learned that the procedure to formalizing the Constitution will include the Jamaican people.
All right, so I'm happy
but
that
I still want to go back to your question. I don't want to leave your question. The question is, would I object to somebody being on the committee who, in fact, embraced that kind of lifestyle? And I said no. But if, like everything else, if somebody confessed, when somebody is going to be a jury, for example, they would ask a certain question. And if by your lifestyle or conviction, you are the proponent of any particular deviance, then you are not included because of the kind of integrity that must be brought to a particular process. And integrity to a process is important as much as and so if anybody is prepared to make clear if anybody is prepared to make clear that I cannot be separated from my practice and insistent, that person should not be allowed to sit on the committee.
However, but by a statement though, you have implied that this individual, speaking of Professor Richard Albert, he's not capable of being or deviating or being separate from the views, because that's just one view.
I'm not questioning his capability. I'm simply saying that along with him is an equally strong position on two practices that are illegal in Jamaica.
Yes, that's one. Now, I'm saying that there seem to be some trust issues, because here we have a 14-member panel, 14, not one, not two, not three, 14-member panel, and if my memory serves correct, the Prime Minister has stated that they're going to do phase 1 to set the constitutional framework, and then as time goes by, then they'll make the necessary changes as we're capable of making when that time comes. Now, I'm asking, what issue or what are some of the apparent objections to the inclusion of Professor Richard Albert on this committee, given that that is the phase that we're going in, and given the fact that he's what you would call a comparative constitutional expert, none of which we have right within the region?
I don't want us to kind of be going around in circles now. The fact of the matter is that there is a worldview that is informing many processes in Jamaica. And the LGBT worldview and lifestyle, and abortion worldview and lifestyle, has informed many organizations and entities. It is best for us to exclude any kind of such imposing worldview in the establishment of our sacrosanct and document that will guide this generation. And I'm saying to you also that you must bear in mind that I am not excluding the most significant role that he is required to play. Because I don't
What
believe
is that role for the record?
It is provide information and learning in the process. But that information and learning can be provided from a consultative position, and he does not have to be included, especially when we know that the pride of place The pride of place that the LGBTQ take in just being included is one that is of significance.
But there are two things, Minister.
Yes.
On one hand, I'm sure that you'll appreciate what was stated in the news earlier by the Minister of Information, that we know that there are 13 amendments to be considered, but the Minister stated clearly that the abortion regulation as well as the buggery laws, those two things are not things that will be addressed in this constitutional reform. Is it that, do you think that he's misleading the population?
You know, I don't, in fact I know, there'll be no statement in that section that will name homosexuality and abortion in the document. But I happen to know that there are statements which can be included, and I am sure that persons representing the church and other places are very mindful and are keeping an eye out. There are statements which can be included and will be considered that, if included in this constitution, can easily facilitate the practices, organizations of the LGBT and abortion.
Give me an example.
There are certain statements that, for example, Jamaica is about to sign a treaty with the ACP, EU, that have things like occupational health and certain other statements that I wish I had the document before me that implies and allows for and cannot be excluded the practices of the homosexuality, of the homosexuals and the LGBT community. So listen to me now. And that is what a document like the Constitution is all about. You know, it's a framework that will facilitate the actions and movements and destiny of a people. Now, if you are careful to put a statement in that facilitate the practices of homosexuals and LGBT community, incidentally, practices that destroy families, nations, individuals, and otherwise, it's going to be legal and binding, and it's going to be illegal for us to exclude them on the basis of some statements. So don't think that I'm not aware.
No man, so
I am fully aware.
We got a number of things from what you have said. Remember, first, one of the earlier questions that I asked is, I stated quite clearly whether or not, I stated that you might have some trust issue with the government. No, I'm asking you directly now.
Yes.
Is it that you're saying that we cannot, as a people, take our government, our own government, elected officials at their word?
You know, I don't want to look at it like that.
How should you look at it?
I'm going to tell you why. Because of the kind of polarization of PNP, GLP thing in Jamaica. But our eyes have to be on the government of the day, whether PNP or GLP, especially as we know that international powers are seeking to get countries to be aligned to their policies and principles. I mean, it is no secret. The United States of America, for example, is very comfortable with the whole practices of the LGBT and certainly abortion, where even now, up to just before delivery, you can have an abortion being done. And our alignment to these places will influence our government, can influence our government. It is for us, the people, to be the vanguard of the kind of policy that guide us as a nation. So I would not even bother ask the question about trust. It might be in their best interest, you know. It might be in their best interest to make statements and to put something that gives them favor with international countries. And I would not be surprised if whatever is likely to be included is not consistent with the people of Jamaicans. And I'm saying to you, so it's not a matter of trust. We are just being the vanguard and keeping an eye out on anything that is likely to compromise our moral standing and culture as a nation.
You said compromise our moral standing. So therefore you're of the opinion that his inclusion might ultimately lead to something like that?
Look here. And let me think carefully now. I am being more proactive, to be cautious, than reactive. Because when the time comes for us to react, it might be much too late, like many other nations of the world that are late, and many of our Caribbean nations are saying, boy, Jamaicans, stay on top of it. We are getting information because we made the mistake of not being proactive and not talk aloud. I'm not asking the question. We have, you hear me say, Jamaica is about to sign a treaty with ACP, EU, and there are statements in that treaty that we have represented the government. We have made representative to the government to say change that statement, and if you can't change the statement, make an additional statement in our document that protect us from inadvertent inclusion in anything that is not culturally sensitive to us, and we're getting a pushback. So I don't rule out that the government who has a responsibility to put us in a national framework of being accepted and of getting access to certain benefits will want to have a statement that is convenient for locally and international. So, but we have to maintain that eye.
So with all that you have said,
yes,
you understand that we can say almost anything that we're involved in,
yes,
there's always a tendency for us to reshape the narrative so that we can be better off for having been there. And we're saying a 14-member panel,
yeah,
we're saying one individual,
yes,
with that view who happens to be a comparative expert in, yes, the area that we want.
Yeah.
What if the government decides against acceding to your views? Yeah. What are you prepared to do?
Make him a consultant and not an inclusion in the committee. I would like to maintain the national pride as a Jamaican to say we have rewritten our own constitution with consultation, advice and information and sensitivity to the rest of the world. But I think this document that is Jamaican in content, policy, principle and everything must be uncompromisingly Jamaican.
Uncompromisingly Jamaican.
And so anybody who has anything to do with it or influence it must in fact be in a consultative position and not as a member of the committee. And
I'm asking, if the government decides against what you have recommended, what are you willing or what are you prepared to do?
Listen, I'm not adversarial, you know, I don't have any plan to be adversarial. And I mean, I them around things, I feel them, they are the leadership at this point in time. You know, I don't know that it's, as I say, there's a second level. There's a second level recourse, which is when the document come to us. We have great minds that are waiting with bated breath to look at the thing. But I will not make an opportunity pass me to speak out against what could very well be motive and intention being germinated, which can have adverse effect. So of course I'm watching him. I would not know the detail of his conclusion. Remember, I'm coming with superior knowledge and information, you know. So I have no doubt that the level of importance that they place on him and this committee make it seem as if he has information and learning that will do better, that we don't have. So it could very well be that when him come with it, it be included. But we have others who are looking out for it. And I am raising the red flag that nobody will feel uncomfortable when we have to hit out against a particular statement that we are fighting now to get off the treaty. The treaty is about to be signed. We're trying to get them to take out two statements, and they will not take it out. You know why they will not take it out? Because these are statements that facilitate the LGBTQ community. But be that as it may, maybe another program. But I'm saying to you, this opportunity, I representing the church and Jamaica cause, in this regard, I can simply say, and there's a sense in which I cannot represent the wider church, right? But listen to me. Generally speaking, we are against anything that is unbiblical, anything that impugns and undermines the dignity of the human race, a part of our national statements. And so we're watching the document. So this failing, I'm not going to take to no streets and block no road.
All right. And with that, we want to thank you for allowing us to have such a robust conversation.
Yes.
And we hope to speak again on this and other issues.
Yes.
Ladies and gentlemen, stay tuned. The conversation continues. Our security guards have been restive. Some are timid in light of all that they have had to face or deal with over the past few months. But more than that, There have been changes in contracts, a lot of things to be discussed. And today on The Conversation, I have with me veteran trade unionist, Mr. Vincent Morrison. Welcome to The Conversation. How are you?
I'm very good, and thanks very much for having me, especially that we're going to talk about this subject matter.
Yes.
Very important.
So it was stated earlier in the year that, well, last year rather, that a ruling was made by the Supreme Court that relates to the status of our security guards. Could you tell us what are the elements of last year's rulings by the court, and how has the security companies deviated from it, if they have deviated any at all?
Well, put it this way, the judges don't make laws. Judges interpret laws.
Yes.
So when Justice Batts, September the 23rd last year, made the ruling, he was actually interpreting a 2002 amendment to the Labor Relations and Industrial Dispute Act, which defines a worker. They call it definition of worker. And the definition of worker constitutes a number of elements, a number of factors like control, time you start work, the time you leave work, suspension, discipline. It also connotates things like whether or not you're part of the business, supervision, and a number of other things. But that amendment from as far back as 2002 signifies that the security guards were not independent contractors, but employees. And the Ministry of Labor have been, the Ministry of Labor has been treating them as
employees.
As employees.
But in terms of the security companies now, do you find that they have been deviating from this particular ruling?
More than deviating, they have been breaching the law consistently over the years. And, you wonder how Parliament, the Parliament is supposed to be the supreme authority of the land. Maternity leave, these workers get no maternity leave, they get no sick benefits. Vacation leave, it was a part of the arrangement in 1974 that sets up the minimum wage arrangements, the Minimum Wage Act. They're entitled for vacation leave from as far back as that. But the workers got no vacation leave as a result. Although the Parliament passed a law which gives them the legal right to maternity leave.
Okay, so in an earlier Gleaner report, you stated that guards cannot sign a document that is flawed or that is not in their favor. Could you clarify that statement?
Yes. Come the 1st of April this year, the company decided to change the independent contract arrangements. So what they did, they gave the guard a new contract to sign. Now that contract, absolutely flawed. I mean, what they are asking the guard to do is to waive their right to a number of benefits. As I mentioned, vacation leave, which they're entitled to under law. The years of service. There are workers who will tell you that they got injured on the job and they are pursuing these matters in the courts. If they had signed that agreement or that new contract, all of that would extinguish, and I'm using a word in one of the, I think it was a guardsman, marksman contract, extinguish all their past benefits, all their past arrangements.
So it's future and not retroactive?
In fact, what the contract was saying, all right, you're going to give you a 1-year contract. These are guys who have 40 years, 35 years service. 1-year contract with 3 months probation. Now, you tell a worker in Jamaica that I've served a company diligently and well for 35 years, And they're now saying to me, I must now sign a new contract, April's Fool Day, that I'll have to start afresh, 3 months probation, a 1-year contract.
So would you argue then that these companies are insensitive towards the plight of the security guards, or is it that because they're now standing to fork out billions because of these new arrangements?
I would say they're not only insensitive, but I think they're somewhat cruel. And you know why I say this? Yesterday they had a little standoff at the Beryllium premises, Blake Road. And I was called. I was at a meeting at the Ministry of Labour. And they called me. I ended the meeting and went straight there. And you could have seen the stress on the guards. You could see the concern. One guard said, how do I go home and say to my wife, 35-year service, and I have nothing to show, nothing to give. But the law is very clear, you know. The law is very clear, and I think officials of the ministry, the technicians, know the law. And I think they have advised the political directive as to what is the correct approach.
So where do they come in now, in terms of the government? Where do they come in, and what role would they or should they be playing in this particular
The Labour
juncture?
Ministry should have stepped in from day one. They should have. We wrote to the minister, asking the minister to meet with a team of trade unionists, because we have been pushing for the setting of the Joint Industrial Council. We should back up a bit here, because the guards are not unionized. They are not unionized, and this is where the fundamental problem is. But this doesn't prevent the government, through the minister, through the Labour Ministry, in starting some dialogue, and meeting with the unions, setting up a team that could have looked into the whole thing and to advise the ministry and the government in a proper way. But what it seems to appear that the government is siding with the wishes or the position taken by the companies.
How so?
Well, both the Minister for Information, Minister Morgan, a young man who had, admired in a certain way, he made a statement that the government can't intervene. It's between the guards and the company. Now, some of these guards are not very, very literate. They have given contracts, legal documents that they can't understand, they can't interpret. So we think government had a role to play in this by ensuring that the laws of Jamaica are upheld.
But to the minister's point, though, he was recorded as saying that the security guards should go to the Ministry of Labour. Wasn't that what he said as well?
He said that. Mm-hmm. But you're talking about 25,000 guards. What the minister is saying, all the 25,000 guards who are affected in this matter should write to the ministry or go to the courts.
Or they could get a proxy and they write through this individual or organization.
Well, that could be. But the Ministry of Labour has the responsibility to ensure that justice is done, right? You're not asking anything too difficult when a group of non-unionized workers is important to the security guards. And we know the problems that they're coming under now with the criminals and what have you. The time was extremely right and ripe for the government of the day to say, look, this is a concern. We are going to deal with it. Because the Ministry of Labour has dealt with this issue number of occasions. Alcan Jamaica Limited, when they moved from one company to the other, that was sorted out. And there's a number of precedents, examples. But I'm satisfied that the technicians in the ministry gave the political director the right the right information, the right instructions, and the right advice to deal with this situation.
All right, so backing up a little, earlier you stated that the government, or well, not the government, but the security companies are in fact cruel. Yeah. So it's safe to assume, it's safe for you to assume that there's an atmosphere of coercion that's there for them to sign.
Yes.
All right, now, given that, what I want to find out now, this is now a transitionary period, and we have roughly 24,000 officers. You stated roughly 25,000 officers transitioning from independent contractors, as you said, to employees now. How can your organization facilitate this and ensure that their demands, or justice rather, is served and their demands are met?
Before I answer that question, I just want to give you and your listeners what is happening to the Guard as we speak. There are a number of guards who have not signed the new contract. Those guards are being laid off. They turn up for work, they are assigned duties, they turn up to work, and they were told, look, because you didn't sign the contract, we're not going to allow you to work. I think this is wrong, totally wrong, because you can't terminate a guard because you give him a contract that is totally against his interest. And because he refused to sign it, you're going to virtually victimize him. Don't allow him to work. But here's the problem. Some guards have signed, and they have said to me, look, I had no choice. I'm the only, one lady said to me that she's the only breadwinner in the house. And if she don't sign, the kids can't go to school the following day. And therefore she signed under duress. So you don't have a situation where you have workers working for you for 40 odd years, 30 odd years, 16 years. And you put them under this pressure. You said if you don't sign, there's no work. We suspect, however, that the company may have some challenges with respect to cost, you know.
All right, let me put you on hold right there because we're going to a break, and we'll come back in a bit to tidy up this. Ladies and gentlemen, the conversation continues. Today in the conversation, we are having a discussion with Mr. Vincent Morrison, President of the Union of Clerical, Administrative and Supervisory Employees, UCASE. Mr. Morrison, just before we went to the break, you were discussing the plight of the security guards, and I have here a clause from one of those contracts. It reads thus: I hereby confirm that I have no pending claims, proceedings or disputes with you of any nature whatsoever, and that I waive any claims or disputes that I could have. I unconditionally release and discharge you from all past liability to the fullest extent possible under law. Is this one of the primary reasons why the security guards are restive, and what are the implications of such a clause?
Absolutely. It's basically the center of the dispute. Because what the guards are saying, if they signed that, then they would have waived their rights to all their past year service. They would have waived their right to their vacation leave, which the company has been paying vacation leave to employees as we speak. But these group of workers, if they sign that, effective the day they sign it, they would waive their right to that. And the company would be in a position to say, but you sign this, you give up that. Right? So the point is that the workers are saying, we are prepared to sign the contract, but not with these clauses. We want modification to the document. And they're right, because a contract is a document between two persons. right? It can be one side give you a contract and say sign, and the issues of this sort, issues of that clause. I know there are other clauses, but this is the main one in the agreement. And we believe that the workers are correct, having said, look, we're not going to sign unless that is modified.
So how can your organization or others like it facilitate them getting better representation?
Well, first and foremost, we would have thought that the Labor Ministry would have been the forefront to deal with this issue. Organizations such as mine, we are talking to a group of lawyers. We had a meeting with at least 2 or 3 of them this morning, and what I can tell you is that the advice that we've been getting is that they would want to talk to the company first and foremost, to see whether we can have dialogue, some sort of conversation which could resolve this situation. If that fails, then they may have to proceed to the courts. Because what is quite clear is that the Labor Ministry has vacated their position in the whole conversation. And as I said, I think it is the Minister of Labour and his technocrats should be leading this issue out there on behalf of the workers, mainly because the workers are not unionized. And I can say this, that if the workers were unionized, we wouldn't be having this problem. Because in unionized establishment, you don't have this problem. Because this is not a new situation.
All right, so is it too late for them to become unionized now?
It's a process. Not late, but it's a process. It will take some time. And we are working on that aspect of it.
What time span are we looking at?
Well, we believe that perhaps end of May, June, perhaps we could get the ball rolling. In the meantime, what is crucial is that workers are being coerced to sign this agreement. They are being laid off. And I wish to make the point that if you lay off the workers, certainly, at the end of 120 days, he would have the right to claim redundancy payment.
All right. Do you think that this would be a matter for the Office of the Public Defender to get involved with?
Yes, and we are going to contact the Public Defender on this matter. Fundamentally, we think it is.
So we're saying that litigation is probable, and the Office of the Public Defender is definitely one to assist with the process, and you're saying that it's not too late for them to become unionized.
It's not too late.
It's not too late.
And it's not too late for dialogue. For the companies, through the Jamaica Society of Industrial Security that represents all security guards, it's not too late for some sort of conversation, dialogue, discussions. We would want to hear from the company exactly what are their fears, what are their concerns. Is it that they have done the calculation as to what they would owe the guards and they can't afford it? This is something I'm sure the guards would be very willing to sit down and look at. Right? I'm sure the guards wouldn't be against discussion. But, it can be done 2 ways. You can say to the guards, look, we are moving to a new company, as in the case of Guardsman, Marksman. Mm-hmm. We can carry your service to the new company. And that would solve any problem as it relates to cost. Because this is what the security companies are now asking. They're asking that the guards sign within a new company. And what is the law as it relates to that? What is the practice? Yes. You can carry the service over as unbroken.
Okay, so I'm looking at the genesis of this issue, and it seemed to me, history tells us that it was based on the NHT claims.
Yes.
All right, now we understand that these companies are $billion, some even multi-billion-dollar enterprises. Do you think that they're afraid of reducing their profit margins, and because of the existence of such fears, then that's why they're taking this kind of action?
Yes, I would believe so. I think most of these disputes, these impasses, would involve the company taking a hardline position, looking on their bottom line, looking on the cost to pay legal benefits. I think that could be a situation. But what I can say, having spoken to the guards want to work. They want to continue to work for the companies. So if we can sit down with the companies and work out an arrangement to structure what you owe them over time, over a period, so that wouldn't be a problem. And I think that is where the Labor Ministry would have a role to play. I would also want to mention that we have been asking the government to lead in setting up a joint industrial council. Up to 1988, there was a joint industrial council. It went under, and industries as large as this one, I think that's an approach that the government should take. You have in Jamaica, in Kingston, in the big cities, a lot of workers working in areas like hardware, shop and offices. These are areas that Joint Industrial Council ought to be looked on as a policy direction. So
this Joint Industrial Council will seek to encompass all those individuals?
It would include the government, it would include the companies, it would include the trade unions.
And that would mean better representation?
And that would mean you would have continuous representation for the guards. It would go a far way in settling a number of the issues that confront the guards.
All right, so we have come to the end of our discussion as it relates to this matter. I want to thank you for having sat and allowed the information to flow so freely, and we hope to hear from you again. Ladies and gentlemen, there you have it. This is the conversation, and I just spoke with Mr. Vincent Morrison, President of the Union of Clerical, Administrative and Supervisory Employees. This is the conversation, and I am Kwame Thomas.